Thank you for staying with us. It is about 4 days since the Supreme Court gave an order that the old 200, 500 and 1,000 Naira notes should remain a legal tender till the end of the year. While many Nigerians would have thought this news would bring relief, it remains to be seen as the federal government and Apex Bank are yet to give a directive to all the other banks. Although the Supreme Court is the highest court in Nigeria, with no one being above the law, the CBN and federal government are yet to give a go-ahead for the old notes to continue being a legal tender. Recall that on the 16th of February, President Buhari gave a directive for the old 500 and 1,000 Naira notes to stop being in circulation, even as the Supreme Court extended the deadline. Well, joining us in the studio is a lawyer and an advocate for good governance, Inibehe Effiong. Good morning. Thank you for joining us.
Thank you for having me.
Great to see you.
Good to see you.
Thank you.
Right.
Thank you.
Right.
Now, the silence from the federal government and the CBN is deafening for a majority of Nigerians who have been waiting with bated breath on what direction the government will give as to if they would adhere to the ruling of the Supreme Court. What do you make of this silence?
It is actually one that is quite curious because by virtue of Section 235 of the Constitution, the finality of the determination of the Supreme Court is enshrined to the fact that without prejudice to the powers of the President regarding prerogative of mercy under Section 175 of the Constitution, and a governor of a state under Section 212, the decisions of the Supreme Court or any determination of the Supreme Court shall be final. Shall be final. It is not appealable. When the Supreme Court has determined a matter and you are not satisfied, all you can do is to, maybe express your dissatisfaction or appeal to God. And of course, nobody knows how to appeal to God except by prayers. So when the Supreme Court has reached a decision, Section 287 of the Constitution, subsection 1, says that the decision of the Supreme Court shall have binding force on all authorities and persons throughout the Federal Republic of Nigeria and on all courts that are subordinate to the Supreme Court. Authorities and persons within the purview of Section 287 includes the President, the CBN, the banks, and every single person and institution. Now, in this instance, the Supreme Court has reached a decision, one way or the other, to the fact that the monetization policy or the Naira Redesign policy or whatever nomenclature we want to ascribe to it, the manner in which it was done was faulty. The process itself, the policy itself was not valid. That decision has been rendered. But because the CBN was not a party to that suit,
right,
and because the Supreme Court has said that the CBN is an agent of the federal government, right, and that the federal government is an agent of the federation, I expected that the certified true copies of the decision, or at least the enroll order, would have been obtained by now, served on the Attorney General, even though he was represented in the matter. That is for purpose of procedure and regularity or bureaucracy. And then that the AGF would have notified the CBN officially. Because I tell you, even though I have read that some commercial banks are already issuing the old notes, I know that most of the banks may be quite hesitant to comply except they get directive from the CBN. So I would have thought that by now, the AGF Malami would have acted to ensure that the orders of the Supreme Court is enforced, because the AGF, by the Constitution, is the chief law officer of the Federation. He has that onerous responsibility to ensure that court judgments are enforced, court judgments are obeyed. I do not understand why the Malami is silent on the matter. And the moment the Supreme Court has determined a matter, that judgment takes effect immediately. It is not a question of, how do we go about it? The judgment is clear, the judgment is explicit. The Supreme Court even set a deadline of 31st of December. Of course, there are some, interrogations within the legal community about certain aspects of that judgment, which I may not want to delve into. But because the Supreme Court has reached a decision, that decision has to be obeyed, whether you are comfortable with it or not. Because really there is no alternative to the determination of the Supreme Court. You are bound by it. You are under an obligation, a legal obligation. It is not a moral duty on the Malami to do this. It is a legal duty. It is a legal duty that he has to follow. It is a legal duty that he has to comply with. So I don't understand why he has not done that.
The majority of Nigerians expect that he should understand this and so comply immediately, but we are not seeing him react.
Well, again, you shouldn't be surprised. Anyone who has lived in Nigeria in the last 8 years, anyone who has been a witness to the culture of impunity, the reckless disregard for court orders that we have been complaining about. I've had cause to speak on this, studio a couple of times. Shouldn't be surprised that we are seeing court orders being flouted. Several other court orders have been flouted without consequences, which worries me as a Nigerian, worries me as a lawyer. I expect that this, judgment should be complied with, no matter the reservations anyone has about the judgment itself, whether, the tenets of the judgment, the tenor of the judgment, some issues regarding that the president did not seek the advice of the National Economic Council and the Council of State and so on. Some lawyers are raising questions on whether there is actually a requirement of law to that effect. But all that doesn't matter anymore because the Supreme Court has taken a position.
And that is binding on anybody within the federal government.
Now,
for the purpose of enlightenment, give us this. We recall that the Supreme Court was supposed to give judgment on this issue and deferred or shifted it, I think, about twice.
Yes.
Nigerians expected that this would have come even before the election. But however, in the wisdom of the Supreme Court, they decided to defer it up until after the election. When these kind of deferments are made, tell us the reason why some of these things are done in this way.
It was a very intriguing scenario that played out at the Supreme Court. Some of us were not particularly surprised that judgment had to be deferred to the later date. One, because many states had filed joint applications seeking to be joined as parties to the suits to originating someone at the Supreme Court. When there is a joint application, it is a priority application that the court has to first entertain to determine who is supposed to be a party on record in the matter. That also contributed to the delay in the delivery of the judgment. That is at the technical point. The other aspect is that the Supreme Court had already made an interim order saying that do not stop collecting. Let the old notes continue to be in circulation in pari passu with the new notes until the motion or notice is determined. Now, ordinarily by law, a motion or notice, an ex parte order is supposed to be interim in nature. It is supposed to subsist pending hearing and determination of the motion or notice, which is actually what the Supreme Court had said. But somehow, even though the motion or notice for interlocutory injunction was pending, we knew that it may be hard for the Supreme Court to delve into the interlocutory application that was pending. And as we saw, when the matter was heard, the Supreme Court simply adjourned for judgment. So when the point was raised at the hearing date that the federal government was in contempt or had flouted, in fact, I think Kaduna also, one of the states, had even filed an application regarding the disobedience of the order of the Supreme Court. The Supreme Court did not make a specific pronouncement on the hearing date. But in the judgment that my lords delivered, they were unequivocal that the disobedience of their interim order was against the rule of law and democracy. They even deprecated the president and the AGA for not complying with the order that they had made. So I don't think the Supreme Court did anything, particularly out of, point in deferring the judgment, because if you look at even the processes that were filed, there were multiple processes by various states. As a matter of fact, even on the day of hearing, some states were still trying to put their papers their processes together. The federal government also was still struggling to respond to some of those processes that were filed. So they just had to shift it. Now, did that really have bearing on the presidential and National Assembly election? I know, because in my polling unit where I voted, the argument that the president made in his broadcast, insinuated that, look, this was going to reduce vote buying and so on. Did it really have that effect? I want to believe so, because for the first time in my voting life, I saw an election in my polling unit where nobody was sharing money. I mean, where do you don't even have money to buy Gary and Maggie, and you want to go and buy votes. So I saw an election in my own unit. I'm speaking about my unit, where nobody saw shishi.
But some person said that it made vote buying cheap. The person you would have bought for 5 or 10,000, 1,000 became very, very valuable for the person.
EFCC also caught some persons.
Yeah,
they're not serious. They are not serious.
Those making transfers.
No, they are not serious. They are not serious. For me, when I see EFCC, those, I think they are just dramatizing.
Why do
because
you think so?
part of the issue, reservation some of us expressed about this policy, is that if the intent was targeted at vote buying, CBN knows how much they have disbursed to the branches of the banks across the country. The records are there. If you needed to know who the banks were giving these monies to, as it was reported, they could have simply asked for records. We have given you this bulk of money, this volume of money. Let us see who collected what. That was not done. So, as I'm talking to you, except these things are taking place behind the scene.
But we had a situation where a House of Rep member in Rivers State was said to have been alleged, arrested for with about $500,000.
Which is commendable. Even in Lagos, EFCC announced that they had found someone with a lot of money of the new notes. When are they having their day in court?
Interesting.
That is the question.
Right.
Because we should not just be dramatizing these things. Agencies of government should not just be coming to the public space to make statements, to make utterances that translate to nothing at the end of the day. When are they having their day in court? I want to see that transparency for Nigerians to really be convinced that the federal government was pursuing this policy in good faith. If you were pursuing this policy in good faith to ensure that there is no vote buying, and you have said you caught some people with money, when are you taking them to court?
Absolutely. Now, the next question is the matter of, there are those asking that perhaps the president and those involved should be held in contempt of court for not, obeying the court orders thus far. Because, yes, the president has spoken that only 200 Naira will be made available, the 500 Naira and the other 1,000 Naira are no longer legal tenders. I wonder if you are hoping that will
No, it's not possible.
Right.
Factually and legally, it is not possible. Right. Factually, because who will arrest the president? Who will hold the president in contempt? Legally, Section 308 of the Constitution clothes the president, the vice president, the governors, and deputy governors with immunity. That has become a constitutional impunity, an impunity clause. Nobody can hold the president in contempt because if you look at the process of committal, you will have to issue Form 48, notice of consequence, notice to show cause. You go back to issue Form 49. Those forms have to be issued and then served on the president personally. That is what the law says. And Section 308 says, no process of court capable of requiring the personal attendance of anybody that is granted or covered by that section shall be issued or even applied for. So legally, you cannot hold the president in contempt, just as you cannot hold a governor in contempt. Of course, that may become an impeachable offense. That is not to say there is no remedy whatsoever. Of course, the Supreme Court can also, make some orders. The person that can actually be held in contempt is the Attorney General. It's not the President. It's the AGF, because on record, in the case of the Supreme Court, the President was not a party. It is the AGF who represented the federal government of Nigeria, the government of the Federation. So I expect that Malami will comply, But it looks like, the governors may also, who went to court, may also find a political way out of this. I don't see the governors going back to the Supreme Court to ask that Malami be committed.
What political way are you foreseeing? What political ways out of this are you seeing? What do you foresee?
I foresee that after the governorship election, the situation will stabilize. I have, my instinct tells me, it will be terrible if it does not stabilize. I mean, a lot of people are going through a lot. Things are really hard out there. I don't know, as I'm talking to you right now, since this policy started, I've not had 2,000 Naira cash in my pocket. I have had to depend entirely on online transactions. The apps are not even working efficiently. So it has been very difficult for Nigerians. But of course, I said the argument that, look, this may also aid, to sanitize the electoral process. But that should be a systematic thing. It shouldn't, because are we going to have a new Naira redesign policy in the next election? Are we going to have to redesign a new currency to stop vote buying? So what are the policies we are putting in place? The problem is that we have an electoral act that has prescribed undue influence, that has prescribed the buying of vote, a criminal offense, that has never been seriously pursued in this country. I'm not aware of any politician in Nigeria who has been put on trial for vote buying. I'm not aware. Even when people are arrested during elections, they are released at the end of the day. Nothing is done to it. The laws are already there that nobody is seriously enforcing.
Why so? Why so?
Because in this country, we politicize everything. Are we going to have a new Naira redesign policy in the next election? If the president is really serious about stopping vote buying, that is the motivation behind this policy. Let us have an institutional way of addressing these things so that it doesn't matter who the president is. It doesn't matter who the candidate is in an election. The laws are already there that has criminalized this act. How come these laws are not obeyed? Even in the primaries of the parties, EFCC told us, we saw how they were, doing their normal comic thing, going around. Nothing came out of it. So I'm not very confident that those they claim they arrested, who they caught with money in Rivers and Lagos and so on, will be prosecuted at the end of the day.
Let's look at it from the technical point of view. In a situation where somebody is arrested with an amount of money, and there is even a list of, who the money should be distributed to, but he has not distributed the monies yet. In the eyes of the law, the person has not conducted the buying of the vote.
Yes.
How is that? How does that make him guilty before the law?
Well, in law, an attempt is also a crime. Yeah, conspiracy is also an offense.
True.
The actual commission need not take place. Once there is evidence that the machineries were put in place to commit an offense, you can't be prosecuted. For me, it will also be interesting to see the charge. The other aspect is money laundering.
Yeah.
Under the Money Laundering Act, there is a limit on how much an individual can disburse for any purpose in cash. So that person will now have there now has to be an explanation on what this money, this physical cash was meant for. And because there's even a list of persons that these monies were to be distributed, that may be money laundering that can be prosecuted in court. But again, I must caution that the prosecution will face an uphill task. It is not going to be, an offense a charge that you can just prove by wave of the hand. There has to be solid evidence. They will have to go beyond the physical cash, beyond the list. There has to be a trail. They will have to look at the accounts that this money came from. What bank was it withdrawn from? Was the intention disclosed? Because even within the banks, if you go now this morning to a commercial bank and say, I want to withdraw 100 million, I want to withdraw 50 million, they are not just going to give you that money and say, go away. They have an obligation by law to notify regulatory agencies. So was this done in this case? These are the questions that the prosecutors will have to
wouldn't that
ask.
be seen as part of the reason why it's challenging to prosecute these things? Because if it's going to be an uphill task to prosecute someone in the instance that you have just put forth, then it becomes a very challenging issue. Maybe that's part of the reason we don't see...
No, it is possible that person has made a confessional statement. Okay. It is possible some of those in the list have already collected the money. And they may also volunteer statements to law enforcement agencies. Okay. We do not know the evidence that the EFCC or the police has. My issue is not about the legal challenges. It's not about the burden of proof. It's not about the credibility or the probative value of the evidence. It is a political will to prosecute. Does it really exist? Just like we have, with thuggery in the country. Political thugs in Nigeria have some sort of special immunity. Nobody is ever seriously prosecuted. The problem with this country is lack of adherence to the rule of law. It should not matter who the president is. It should not matter who the Inspector General of Police is. It shouldn't even matter who the IG is. We keep saying we took our presidential system from America. Look at the US today.
Yes.
Joe Biden is under investigation. Absolutely. Guess what is being investigated for by the special counsel? Mismanagement of classified documents. Will that even be taken as an issue in Nigeria? Donald Trump, as I speak to you, is going through a series of litigations, both civil and criminal investigation. You know, part of what the charges is likely going to face is for trying to interfere in the election in Georgia, if I'm not mistaken. So you have a situation where laws are put in place to checkmate excesses. Because the nation that operates under the rule of law is supposed to be a nation where everybody is subject to law.
Absolutely.
Whether you are president, whether you are vice president, whether you are chief of army staff, whoever you are, the law is supposed to be supreme. But in our country, we see a lot of things. And you wonder, do we really have laws in this country that even judgments of the Supreme Court will come, and it is as if nothing has happened? The Supreme Court of a country is the last resort. It is not called the court of last resort for nothing. It is not called supreme for nothing. And they don't have to be right. They don't have to be right.
All right, that's another issue.
They don't have to be right. They said we are final, not because we are infallible. Or we are infallible not because we are final. So they don't have to be right. They don't have to be right.
Why wouldn't they have to always be right? Because the point there is that it is seen, like they say, that the court is the hope of the
common man, the last hope of the common man.
And when they say justice done and justice seen to have been done, we always make reference to the seen to have been done. If the Supreme Court, because they are seen like the God, the all-seeing, all-knowing and all of that, it is assumed that they should be right every time.
No, the Supreme Court has already said in Adeko case that look, we are not final because we are invaluable. We are invaluable because we are final. So when they have, when I started, I said that, look, there have been divisions of the Supreme Court that has evoked serious debate within the legal community. You have the Imo State judgment is one of them that raised so many issues, so many arguments in the legal community. You have the Ahmed Lawan's case that I, as the lawyer, cannot explain to you. You know that he ran for Senate. He lost at the primary to Asiwaju. But now he's the senatorial candidate of his, in fact, he's senator-elect. The electoral house says you cannot run for two positions. Same with Akpabio. So there are some of those decisions that my lords would have had valid reasons for giving them. But even when you don't agree, because they are supreme, you still have to follow. And as the lawyer, I cannot tell you not to obey the Supreme Court. Right. It's like saying, come and take my wig and gown. The Supreme Court has to be obeyed. The best, at most, what I can do is to, find, in a very, nice language and tell you, oh, these are areas that I feel should have been different. But you cannot say, we are going to disobey the Supreme Court because they are wrong. We are going to disobey the Supreme Court because the Supreme Court has said what the law is. If the Supreme Court says, oh, that a Corolla is Ford, that is the law. It is not for you to say, because Corolla is Corolla, I'm not going to obey Supreme Court. You must obey Supreme Court. But in this case, I believe my lords may have also taken into consideration the suffering in the country, what is going on. They are Nigerians. There's no Supreme Court justice that does not eat Gary likely. But they buy Gary in the market, they buy fuel. They know what is going on in the country.
But the concern for some Nigerians is this constant flouting of the Supreme Court orders, not obeying and all of it. What it poses, the danger it poses for a democracy like ours.
Like the federal government cherry picks.
It's a terrible thing to happen to a country. That it is easy for the president to say, I'm not going to obey the resolution of the Senate or the House of Reps or the National Assembly. We have seen that repeatedly. We have seen cases where the Senate and the House will pass resolutions on the same matter. The president will disobey because the courts have ruled that resolutions of the National Assembly are persuasive. They don't have binding force. If the National Assembly wants to compel something to be done by the executive, it has to be through legislation. But in the case of the Supreme Court, Section 287 of the Constitution is clear that every decision of the, not just Supreme Court, of all courts, must be obeyed. You have to comply whether you like it or not. But when you don't comply, what you have done is that you are setting fire on the Constitution.
Right.
You are basically telling the whole world that you are running a lawless country, that you are in a banana republic. If you don't obey the Supreme Court, what will happen to the country? The president swore an oath to uphold the Constitution. The same thing with the Attorney General. So the other aspect of this that consequences may arise later is that within the legal community, people may begin to say, is there a way to punish the Attorney General? Because this violation has been going on for too long. They are documented. We saw it in Zasaki's case, we saw it in Dasuki's case, we saw it in Showere's case. There have been so many cases of flouting of court orders. I know the pain I feel as a lawyer when I get judgments and I cannot enforce them. I can list cases I have judgment for my clients to do that I cannot enforce. Against the government particularly. You write to them, they will even ignore you. They don't even have the courtesy to respond because they will ask you, what can you do? In fact, police will tell you on the road, this is the other implications of this disobedience now to the average Nigerian. The police will continue to turn to you as a lawyer, as a Nigerian, and say, go to court. I'll shoot you and nothing will happen. Why do you think law enforcement officers make that statement? Part of it is the culture of disobedience to court orders. Because if you get a judgment today against the military or the police, I'm just giving what Nigerians can relate to, you cannot enforce it. Because the Sheriff and Civil Process Act says you need the consent of the government to enforce judgment against the government. And then that consent is never given. So the culture of impunity and disobedience to court orders transcends whatever political considerations Malami may have about the judgment. They have to obey the Supreme Court for the sanctity of our institutions. It is not about, now it is not even about the debates on whether the case of the governors, I had reservations on whether the regional jurisdiction of the Supreme Court was properly invoked in this case. I will not pretend about that. I had expressed some reservation that is before the judgment that, look, I did not believe this was the case that merited a direct invocation, that it should have gone to the federal high court. But my lords have taken a different position. And I have a duty to obey. The same thing with Malami. And their lawyer, a very respected senior advocate of Nigeria, Ganu Agabi SN, had said they were going to comply. So I expect that by now, Malami would have issued a memo to the CBN. CBN would have issued a memo to the banks.
This draws attention to the call to separate the office of the Attorney General from the Minister of Justice. Now, in a situation like this, we would have seen the office, the part where somebody is Attorney General, actually trying to speak to government to say, no, we have to uphold what the standards of society is. But the politician in the Minister of Justice will see where he will stand to defend his principle or defend whatever policy of his government that he belongs to. So does this throw light on the importance of the separation of the office?
Absolutely. The major has the fact that these two positions are merged, it has not helped our country. It has only taken us backward. I cited the case of the US. Because people will now say, oh, that is America, they are advanced. How about South Africa? How about South Africa, where the Attorney General can investigate, we have seen investigate the president.
Yeah.
How about Peru, that is even in crisis, where the AG is investigating the sitting president for the killing of protesters? How about Israel, where the Prime Minister was investigated by the Attorney General? And they even went to court to file a case against it. So there are several examples that one can give. But in Nigeria, every Attorney General sees himself as the personal lawyer of the governor or the president. That is wrong. I recall the last time I was here, I mentioned that most Nigerians are not aware that we have a state house council in the country. There's a lawyer in Aso Rock called a state house council. He's the personal lawyer of the president on official matters. It is not Malami. Malami is not Buhari's lawyer. If I go to court now, in this petition, supposing, in fact, like we saw in the article's case, that is why Malami could not represent him, because he's not a lawyer to Buhari, he's a lawyer to the Attorney General of the Federation. But in Nigeria, Attorney Generals of states and the Attorney General of the Federation, they see themselves as stooges of their appointor. They don't investigate. I have most likely filed more public interest cases more than the Attorney General. I'm not saying that to, make this about myself. I'm just making the point that the AGF is supposed to be the #1 public defender.
Right.
He's supposed to go to court in the public interest. When impunity, when agencies of government disobey court orders or act contrary to law, it is the responsibility of the Attorney General to hold them accountable. It is the responsibility of the Attorney General to ensure that the country is properly governed. But in Nigeria, it is we in the human rights community and the civil society. Serap has to go to court today, over everything. Femi Falana has to go to court. It's not supposed to be so in a normal country. Even though the civil society has its role, human rights community can do those things, but by law, it is the duty of the Attorney General to defend public interest. Guess what in Nigeria? In every single case I have filed against the government for one act of impunity or the other, it is the Attorney General that comes to court to defend the impunity. They come to court to make excuses, to tell the court why the impunity while the lawlessness had to take place. If you violate the rights of a citizen now and you sue the government and join the AG, when the AG comes, it's not speaking for the person whose right is violated. It's defending the violator. There are several cases I can give you that this has happened. It happens every single time. They will always come to court to make excuses why the laws of the country should not be obeyed. So we have a duty as a country to split that office. Let us make it competitive. Let us insulate it so that the AG will not be political. Let the AG not be seen as the legal advisor of the political party in power. One of the sacrilege that this Attorney General committed, Malami, was when as AGF, he went and swore in, I think, members of the APC, NWCs or something at the time. That shouldn't have been tolerated. If you are AGF, it is a position of honor. It is not a position that should just be given for political consideration. The AGF should be somebody that can look at the president in the face and say, no, sir, this is what the law of the country says. You cannot do this. The AGF should be somebody that is above board. The Attorney General's office is supposed to be highly respected. It's the only ministerial office under the Constitution that is specifically created. There is no other office of minister that is expressly mentioned in the Constitution other than Minister of Justice and Commissioner of Justice in the states. That shows the peculiarity, the special nature of that office. That shows the importance the Constitution ascribes to the office. And guess what? Section 150 says the Attorney General shall be the chief law officer, not chief lawlessness officer, which is what they have become.
Yeah, but the National Judicial Council, they all have ideas. They know these issues very well. We expect that since they know the importance and the consequences of what's going on, where people are abusing their Attorney General and Minister of Justice and are abusing the process and all of that, can there be a pronouncement or an arrangement by either National Judicial Council or the Supreme Court, whatever the thing is, at the highest levels of the judiciary, to separate these two offices?
No, it has to take constitutional amendment.
Okay.
Right?
Are we pursuing that already?
I am aware, I think that was the last thing we discussed when I came here, that part of the bills the National Assembly has passed and sent to the President for assent, I think one of those bills is to separate the two offices. I don't know if they are going to sign it. I don't know if they will allow the process to go on. It has to take legislation, not just legislation, constitutional amendment for that to be done. But is the political will there? Because the fusion of the Malami that I know, that I have taken to court, that I have seen come out to defend disobedience of court order, is not going to support it.
All right.
And usually when bills of such constitutional significance are passed, the President will need the comment of the Attorney General. I don't see this Attorney General making recommendation against himself. So maybe let's hope the next government will take it seriously. But for the interest of our country, for the interest of the legal profession, we have to insulate that office. But the NBA must also be resilient. Because every Attorney General is a member of the legal profession. He's a member of the Nigerian Bar Association.
Yes.
He can be disciplined. They can take his son, his silk. We have seen that with Donto and Doka. They can document it, take him before the disciplinary committee, take him before the privileges committee, if he has disobeyed court orders.
All right, we have to leave the conversation here now. Inibehe Effiong, lawyer and advocate for good governance. Thank you for your time on the
My pleasure being with you.
Thank you so much.
Thank you so much.
Thank you. Right.